Good morning, Carla Hartley here. I am coming to you on August 14th, 2020, and today I am concluding our discussion of business valuation in a family law context in California. The last point that I want to talk about with hiring a forensic accountant, and at this point, if you've listened to all the prior videos, you've made the decision to either hire or not hire a forensic. This is for people who have decided to go ahead and hire the forensic accountant. So your forensic accountant can be structured in a number of different ways, and that structure is important. First, do you want to have a joint expert? Do you want an expert that you share with the other side? Generally, this is an expert who will be appointed under Evidence Code Section 730, and that expert will be loyal and owe a duty to neither party but to the court. Since the duty is owed to the court, generally this is deemed an impartial, neutral expert, and this guy or this woman will go a long way towards getting the parties to a settlement. At least we'll have a number, we'll see where the problem areas are, and sometimes you end up having the neutral expert assist you either in a settlement conference or at trial. So the nice thing about the joint expert is generally if the parties are fairly similarly fixed, they will each contribute to the cost of the expert. If not, a lot of times the business will be what pays for the expert. So you're going through this business valuation proceeding, you get your report, and one party likes it, say the other party's got some questions, doesn't like it. Cannot tell you how many times I have been able to sit down in a room with opposing counsel and both my client and opposing party with the joint expert. And the joint expert has gone through the report, explained what they looked at, explained what they didn't look at, answer questions, and so on and so forth. Get to a resolution. A lot of times this gets us right to the resolution. We usually call it a voluntary settlement conference. It can occur at either location, at either attorney's location or sometimes at the expert's location. This is a good use of time and energy, even if you get the joint expert and later find out that your client doesn't like anything about the joint expert. Doesn't like the report, feels he wasn't heard, feels the guy or the woman was playing favorites. In which case, you are going to look at perhaps, if the case permits it, hiring your own expert. Now, hiring your own expert can be tricky. If there is a 730 expert, the court's going to look at this. If you bring a fee request in for paying your expert's fees, the court's going to want to see that there's a reason to do it, and the court is going to want to see that there is money in the community property estate that would permit this additional expense for your own expert. But the purpose of your expert is to go through the 730 expert's report, look at what he looked at, talk to your client, maybe flesh things out with your client a little more thoroughly, and then go back to the 730. Sometimes the two experts talk and reach resolutions and we get some adjustments in the 730's report. Sometimes we end up in a voluntary settlement conference with our expert, the 730 expert, and the parties, and that's how that works out. And sometimes we go to trial. If you're going to trial, I think it is important that the client have a good idea of the cost-benefit analysis of a trial proceeding. Trials can be expensive when you're talking about experts. It does involve significant preparation on the part of both the expert and the attorney. So you want to make sure the client knows what they are hoping to get out of this. And this is also a place where your expert can be very helpful to you. Now, sometimes you don't want to hire a joint expert at all. Sometimes you might want to just start off from the beginning hiring your own expert. And there are reasons to do that. I'm not going to discuss all of the reasons why I would do that here. I am not going to give away my own strategies and tactics on a free webinar, and I would not think that would be cost effective for me or for the firm. But sometimes you want your own expert. Sometimes you have an expert that has been involved 2 years prior to the dissolution proceeding and has been advising your client throughout, the preparation for the dissolution. That's an expert that is never going to be produced to the court. That is an expert you want to keep covered under attorney-client privilege. You want to keep that expert covered under attorney work product. You don't want to propose them as a potential witness at any point in time. You don't even want them talking to the 730 expert or your expert who is going to testify. That guy or that girl is a secret. So when I'm talking about your own expert that you're proposing to take to trial with you, it is not the person that's been giving your client advice. This is the person that you hired to analyze the business, look at the business for valuation, and then you're going to move with that person into trial. So that doesn't mean the other side can't get their own expert, and you're going to have dueling experts at trial, and again, ask for that cost-benefit analysis. Alrighty, that's the end of this series. I am done with this, and I hope you are planning to have a good weekend. I hope this has been helpful, and I will pick up next week on, I think, a couple of comments about income available for support, which is something I've glanced upon but not really concluded.